Sir.
হ্যাঁ ঠিক আছে শুরু করো একটু স্টুডেন্টদেরকে বলো আসার জন্য হ্যাঁ
Okay.
হ্যাঁ
So now I would like to request Mr. Srijan Manna sir, Assistant Professor, Breno University Department of Pharmaceutical Technology, to take the session. Sir, over to you.
Thank you, Brahmajit sir. Myself, Mr. Srijan Manna, Assistant Professor, Department of Pharmaceutical Technology, Brainware University, welcoming you once again to this one-day national webinar on intellectual property rights and industry-academia collaboration, which has been organized by the Department of Pharmaceutical Technology, Brainware University, in collaboration with Department of Biotechnology, Brainware University. A very good afternoon and warm welcome to all the dignitaries present over here, particularly our chief guest and the Honorable Vice Chancellor, sir, of Brainware University, respected HOD, sir, respected speakers, the members of the organizing committee of our university, and our beloved students. Without further delay, I'd like to invite our guest speaker for this session, Dr. S.K. Mitra, sir, and alongside, I'd also like to welcome Dr. Samarjit Ray, sir, the chairman of this third scientific session of today's national webinar. Dr. Ray has completed his MSc from Vishwabharati Shantiniketan, MTech from IIT Kharagpur, and his PhD from Jadavpur University. Dr. Ray has worked as a research scientist in various eminent organizations, including Gufic Limited, Mumbai, IIT Kharagpur, Krishidhan Seeds Limited, and J.K. Agrigenetics. Dr. Ray has also worked as a visiting professor in the Department of Biochemistry, Barasat State University, and presently working as an associate professor in the Department of Biotechnology, Brainware University. It's an absolute pleasure to have you with us, sir. So without further delay, I'd like to hand over the session to Dr. Samarjit Ray, sir. Over to you, sir, please.
Thank you, Mr. Srijan Manna, for introducing me in front of our audience. And good afternoon and welcome to everybody. So it is my great pleasure to introduce our guest speaker, Dr. Sushil Kumar Mitra, who is presently working as a professor and director, Center for Intellectual Property Rights at MS University. So welcome, Dr. Mitra, to our afternoon session for giving your valuable time in the webinar organized jointly by the Department of Pharmaceutical Technology and Department of Biotechnology. So I would like to say a few words regarding Dr. Mitra. So Dr. Mitra is having MSc, PhD, LLB, and being formerly Deputy Controller of Patents and Design, the Patent Office, and Scientific Officer of Central Drug Laboratory, and has 40 years of professional and teaching experience on IPR in different capacity. Dr. Mitra is also a visiting professor of IPR in different national institutes like National Institute of Technology, Rajiv Gandhi National Institute of Intellectual Property Management, and so many. So Dr. Mitra has engaged as a patent advisor of Indian Institute of Engineering, Science and Technology and D.T. Poddar Institute of Management and Technology, and specializes in chemistry of synthetic and naturally occurring bioactive compounds, analysis of modern drugs and their formulation, intellectual property rights, patent system, and their usefulness to scientific communities. Dr. Mitra has published 22 research technical papers and 2 book chapters, and he has visited the prestigious organization World Intellectual Property Organization, WIPO, Geneva in 1998, and European Patent Office, EPO, The Hague in the year 2003, and European Patent Office, EPO, Vienna, 2015 as a trainee and country representative. So he has participated more than 500 IPR workshops organized by different professional bodies like FICCI, CII, FACSI. So without wasting any time, I will pass you over to Dr. Mitra. So Dr. Mitra, please start your presentation.
Thank you, Dr. Samarjit Ray, for giving introduction about me before audience. And also I extend my thanks to Dr. Barik, the head of the Department of Pharmaceutical Technology, Brainware University, and also Dr. Banerjee, who has recommended my name to Dr. Bari for organizing, for participating in this
Yes, sir.
program.
Yes, sir.
Thank you all. I just give you an overview first on intellectual property right, why it is so important today, particularly in pharmaceutical sector and biotech sector. Before going to that, I want to share my presentations. Is it visible? Whether slide is visible?
Yes,
sir.
yes, sir.
Yes, yes.
So, role of intellectual property right, why it is required for research in drug development.
Very
You may aware that in 20 years or 30 years down the line, when we have heard about patent, first it has come to my mind that patent is for drug, patent is for medicine, patent is for pharmaceutical product. But it is not that patent is only meant for pharmaceutical product. Patent is available for all field of technology. There is no restriction about that. There may be a mechanical, maybe electrical, maybe electronics, maybe pharmaceuticals, biotechnology, and so on. So intellectual property right, patent is called the queen of intellectual property right, because patent reflects the development of technology, improvement of technology, new technology. And without technology, we cannot move towards 21st, 22nd century. We have come out from the Stone Age because of our capacity and involvement of the intellectual property and intellectual property right applied to create modern cities and transport, bridge, everything. And after 19th century, we have seen the age of physics, chemistry, atom bomb, polymer technology, modern medicines, drugs, pesticides, agrochemicals, many things are coming. And 22nd century is called the age of biotechnology. We have seen a lot of improvement in biotechnology, transgenic plant, animal, genetically modified seed, genetically modified microorganisms, and so on. So the technology is called the queen, or patent is called the queen of all technology. And other than patent, also there are certain other intellectual property rights that I want to say a few lines about that. But before that, you must consider that intellectual property and intellectual property right, there are two different terms. Everyone has the intellectual property. Intellectual property is something produced using human intellect. That means it is product of mind, which has only commercial value. If you do anything without commercial impact, without only for the theoretical interest or to meet the requirements of your curiosity, then it will not be considered as an intellectual property according to the present definition of intellectual property. So it is, but it should be presented or fixed or to be fixed in a tangible form, because it is intangible nature. Your idea, your concept is your intangible property. Until and unless it will be fixed to a tangible material, that is on paper or CD or in a printed version, then it will not be considered as an intellectual property. So it is often intangible in nature, but usually contain a tangible fixed medium, paper and CD or computer. So what is difference? Difference is that intellectual property, everyone has the intellectual property, I have already said. So whenever you convert to right, then right will be vested on IP. And when right will be created according to the statute, because whenever you create a property, always it should be registered. When you buy other property, flat, land, building, car, everything that should be registered by the respective regulatory mechanisms. But intellectual property right also to be created according to the statute, that is patent law, design law, trademark law, copyright law, plant varieties law, GI law. And we have 7 intellectual properties. It is not that only patent is the only intellectual property. We have 7 intellectual property, semiconductor law. We have 7 intellectual property. And to implement 7 intellectual property laws, we have 3 associated laws also there. One is the Competition Act. When you are going for technology transfer agreement, you have to follow the section 3 of the Competition Act. And next, you have to follow the Contract Act, the common law. Whenever you are going for trade secret agreement, that is the non-disclosure of the agreement or the confidential agreement under the Contract Act. And also another important law is there that is called the Biodiversity Act. Biodiversity Act is not giving you any right, but Biodiversity Act is coming from the concept of CBD, because we are the member of CBD. And whenever you are doing any work with the biological materials or resource available in India, you need to take permission from the National Biodiversity Authority under Section 6 of the Act. So we have also 3 associated laws. That means total 7 plus 3, 10 intellectual property laws you have to know. To implement 7 intellectual property laws, you have to know also the 3 associated laws. But only you must not be confused that your idea is an invention, that is intellectual property. But when it will be registered and patent will be granted to you, then it will be considered as IPR. Patent is an IPR. Your idea is your IP. And similarly, a customer list, price list, secret method of production, all the things is your intellectual property or the company's intellectual property. Whenever it will be protected through confidential agreement under the trade secret policy of the company or the institutions under the Contract Act, then it will be IPR, intellectual property right. Similarly, a particular way of representations, that is also very important, because many things you are doing, but if you cannot express it properly, if you cannot represent it properly, then it will not be good document for you and to the public. For that, way of representations is your intellectual property, that is expression. And whenever it will be converted by a copyright registrations, then that will be your IPR. Similarly, your goodwill cannot be seen in the open eye, but goodwill is associated with the product, with the person, with the institutions, and with the society. So the goodwill also can be protected under the Trademark Act, that which are calling generally brand name, trade name, logo, everything. In the past, what happens, the trademark or the brand only available on the manufacturing product, that is the goods. But now it is also available to the service, because we are paying a lot of service to the society and possess goodwill. Your Brainware University is also providing service for the students. So that also create a goodwill and should be protected under the trademark. So education has become service, tourism has become service, your courier service, catering service, lot of service providers are there who are providing service to the society without manufacturing any goods. So how their goodwill will be protected? That will be protected under the trademark law. After joining TRIPS agreement, we have amended our trademark law and we have incorporated the service mark should be registered under trademark. And also the most important thing is the software. The software also is coming under the protections of the copyright also. So this is the difference between intellectual property and intellectual property rights. Now I'm coming to the 7 intellectual properties already I have mentioned. I don't want to repeat again. But the copyright is very important for the academicians. Whenever you are doing anything, 20 years down the line or 10 years down the line, I have seen most of the faculty members are very much interested to publish papers in reputed journals. So the literary, novel, poem, plays, film, music, drawings, photographs, performing arts, sculpture, even software can be protected under copyright. But copyright is such kind of right that it has no territorial barrier. It is a global right. But other than copyright, all intellectual properties are the territorial right. That means Indian patent is valid in India. Indian design registration is only valid in India. So similarly, I am telling that the copyright is also very an important tool for the protections of your expressions. And now I am coming to a very good examples. I am giving in many seminars this example that the patent, when Sony company first developed the remote control mechanism and applied to televisions, This is the technological aspects, and the remote control mechanisms when they are filed the patent applications and thereafter they have filed the corresponding applications in all the major countries and got the patent on that. And that right can be protected. That right is a patent right, and this protection is given for 20 years. And that 20 years after, that technology has gone to the public domain, and anyone can use the remote control mechanism. And in every where you find that remote control mechanism is available now in operating AC machine or in other device, you can start and stop by a remote control system. Now, thereafter, you see that design. Design is also a very important tool and unique selling point from the kernels of the purchasers. So, design creates the aesthetic beauty of the product. And design, you see, whenever you are creating a design and apply to an article, that design is a matter of registrations under the design laws, and that registration is valid for 15 years, 10 plus 5, 15 year one-time renewal. And so the design is also a very good, unique selling point. Why I am telling? You know, when the technology is same, only design differentiate the two products in the eye of customers. So
Dr. Mitra, Dr. Mitra, Dr. Mitra, excuse me. আপনার স্ক্রিনে নিচের দিকে একটা হাইড লেখা আছে, ওইটা দেবেন, টিপে দেবেন, আমি লেখাটা পড়তে পারি আমরা।
Yes. The design of TV set can be protected by design law, and design right is valid for 15 years from the date of registrations. And thereafter, whenever you are putting any product in the market with new technology or a new process, then new product, then that also carries some goodwill. How can it be protected? Goodwill cannot be protected by patent. Goodwill cannot be protected by design. So that's only protected by trademark. And that trademark is a unique right. Why I am telling unique right? Because it is a perpetual right. And if you renew every after 10 years your trademark, you can enjoy your brand, your name, your logo, whole life, and till your business will be going on. So, but one important thing, whenever I am purchasing any products, a television, washing machine, or a medicine also, if you buy a nasal drop or Trivin, you find a manual is there. That is called the product manual. And that product manual is differently written in different product. And it is also a kind of intellectual property. So whenever you are selling the product, your customer should understand what is the operation procedure, what is the effect of the product, what is the application of the product, what is the other valuable information lying with the product. So all the things are coming with the manual of the product, and that manual can be protected under copyright. So if you put any product in the market with your new technology, you must keep in mind that my product, whenever I will put in the market, I will take all kind of protections from the design law, trademark law, and copyright law, so that I can have the proof, that is the bulletproof protections of my product from all liens of intellectual property rights. Now I'm coming to the very important slide, the intellectual property. This is another example on the pressure cooker I am giving, that every individual input mechanisms is lying in the patented technology. Design in shape and color configurations in the pressure cooker protected under design. The logo, that is the Hawkins or Prestige, that is protected under trademark, and the manual of the pressure cooker is protected under copyright, that is instruction manual. Now I'm coming to the pharmaceutical product. Whenever I have seen in the market, and when last 2 years I was the design in charge of the Indian Design Office, at that time I have found a lot of pharmaceutical companies are coming for registration of their packaging material and different type of drug delivery equipments. Say from syringes to ampoules to capsules to many things, container, that also create a brand. Why? because whenever you are buying a product with a particular packaging material, you can understand this product is coming from Novartis or Boehringer or some Bristol Myers Squibb or East India Pharmaceutical or some other companies. So this kind of packaging material is also registerable subject matter under design registration process. And lot of products, you know very well that the active component also is working as a therapeutic effect. But the packaging material also create a loyalty and create a brand for the companies whenever they are selling the product in the market. And everyone can understand that yes, it is the product coming from that particular manufacturing house. So you see how the design power is using to protect the different packaging materials and the different types of device, biomedical instruments and device to protect their design and the aesthetic beauty of the product. Now I'm coming to the patent. Patent is basically a property, and it is called the intellectual property. And what is the difference? It is ownership, it is transferable, but it is intangible nature that I have already mentioned. When until and unless it will be fixed in a tangible form, you cannot find it, you cannot see it, you cannot read it, you cannot understand it. So it is intangible in nature. And what is the consideration? First consideration of the grant of the patent, that government will give you the monopoly of right and given to the owner for the invention and based on the application. It is not an automatic process. You have to apply it. But trademark and copyright is an automatic process. Trademark without registration you can use. Copyright without registration you can publish and you can have the right. But in case of the patent, you have to file the application, then only registration process will be started. And that registration is given for a limited period of time for 20 years. Now I'm coming to my next slide, that is the patent system. Why patent system has created all over the world in every country? It is a system of encouragement. Someone is saying it is a system of reward. Someone is saying it is a system of giving monopoly of right. But one important thing you have to keep in mind, that without giving the system of recognition, the inventor will not disclose their invention to the patent office. And patent office has the duty to publish after a statutory period of time of 18 months. So for the dissemination of knowledge, and to practice a patented technology before the public forum, this system has given the opportunity to the third party and other scientists to do the further improvement of the technology with the help of their application of mind. So I say that it is a system of dissemination of knowledge. If the system was not there, everybody will practice as a trade secret. So if you disclose to the government will give you the monopoly of right for a certain period of time, and by virtue of applying that right, you can make profit, earning royalty whenever you are putting the invention into practice. You can practice yourself, or you can assign the right to the company, and company will practice it and pay the royalty to you. But always keep in mind, transferring of public property. When it will be transferred to public property? When the term of the patent 20 years will be completed. Or if you don't pay the renewal fees of the patent. In most of the cases, academic institutions, after obtaining patent, they are not paying the renewal fees, and patent becomes seized. And when patent will become seized, then it will go to again public domain. Then anyone can use the technology without falling into infringement, and you cannot sue anyone as an infringer that they are following your process or your product. So renewal of the patent is also very much important to keep the right in force. Always keep in mind. So now coming to we have come out from 1970 to 95. That was the transition period for our industrial development. We have kept the narrow protections in our 1970 Act, only 7 years or 14 years. And particularly for the pharmaceutical product, we are not allowing any product patent. Food, no product patent. And chemicals produced by chemical process, no product patent. Only process patent was allowable. And for the reduced term of patent for food and drug. And 70 to 95, this 25 years, we have enjoyed the narrow protections of the intellectual property rights. And if you look at the precedents, then today's developed countries also, they have kept the narrow protections, their own laws during the phase of industrializations. So we have followed the same thing during 1970 to 1995. And 1991, that is the year for the globalization and economic liberalization. At that time, the finance minister, Manmohan Singh, and the commerce minister, Pranab Mukherjee, observed that we have full strength. So why we will not go to sign the TRIPS agreement, that is the part of World Trade Organizations. TRIPS agreement is an international treaty, and at present in TRIPS agreement, 152 countries are there who are the member of the WTO, and now it is going more and more day by day. So TRIPS agreement is saying that yes, you have the four laws, for design, patent, design, trademark, copyright. But in addition to that, certain new laws are to be created, and the old laws need to be amended. So that we have brought out the geographical indications, because we have the Basmati name was pirated, because at that time we have no GI law. Thereafter, whenever we have introduced the GI laws, then we have registered the Basmati and other geographical indication product like Darjeeling tea, Nagpur orange, Alphonsus mango, Malda Fojli, a lot of things we have registered under GI product also. Thereafter, integrated circuit and semiconductors law we have created, and also we have created the plant varieties, that is the Farmers' Rights Act, for protections of the different varieties of seed, plants, and other materials also. So now we are not making any new law for protection of undisclosed informations. We are following the old contract law, that is the common law provisions, but we have brought out a new laws substituting the old MRTP Act, that is the control of the anti-competitive practices in contractual license, that is section 3 of the Competition Act. So all the things referred in TRIPS agreement, and we have brought out the new laws or amended our new laws to comply the requirements of the TRIPS agreement. Now let us observe what is the minimum mandate for the TRIPS agreement. Minimum mandate was that the uniform term of patent for 20 years should be given. You cannot discriminate in technology, you cannot discriminate in nationality. Any person of any world can protect their inventions without discrimination of nationality and discrimination of technology. And the pharmaceuticals particularly should be available as a product patent, and also accept importation will be considered as a working of patent. Why? Because non-working ground of the patent right is also a ground for revocation of the right, because the public is not getting any benefit of the new technology. So importations, if you are manufacturing the product in other countries where the raw material or labor is cheap, and you can export that product to India, or India also can export that product to other world also. So importation also will be considered as a working of the patent. And compulsory license. Compulsory license is a tool to safeguard our public health issues. So all available in special circumstances. Say for example, epidemics, or say at the time of the corona COVID-19 situation last 2 years, government has adopted a lot of measures to make available in the market the vaccine. And already you know that 150 crores of people have been vaccinated because of our government system and the safeguard provisions provided in our laws. And in case of the process patent, the burden of proof will be reversed. That means the infringer has to prove before the court that he is not following the process of the patent holder. He has developed a different process and making that product available in the market. So minimum 5 important mandates are given in TRIPS agreement, which is very much important for the pharmaceutical industry and research in the pharmaceutical product. So now coming to the patent document. Why I am saying this patent document is very important? Because if you look at the available medicines in the market today, and you find that 98% or more than 98% technology is off patent technology. But how you can have that idea? Only if you go and search. Different patent office have the different database. They are maintaining their own database. Indian patent office has also database. If you go and search with the filing date, name and address of the applicant and the title classification, with combined search, you can have the idea of what are the drugs are now under monopoly of right and what are the drugs are now free from monopoly of right. So it is very important, particularly whenever any company is going to apply for manufacturing any product under the license of new drug applications. So this search is very important, and patent information is a gold mine. I am telling this information is a gold mine. If you know how to conduct search, and if you can reach to the product by a process of search, you not only can understand the patented technology is protected, whether it's India or in any other corresponding countries, you can have the idea. And in our language, we are saying the FTO search, that is the free to operate search. Free to operate search means if that technology is protected only 20 countries and rest of the 130 countries, this patent is not there. That means that patent is a territorial right. US patent is valid in USA. Japanese patent is valid in Japan. Indian patent is only valid in Japan. The rest of the 130 countries are free for you to manufacture the product and export the product in those countries without falling into any infringement. So the patent information system and the patent document is very important for knowing your research also. Why? Because I have seen in my life, in my career also, that we have started a research work without going into any search. But thereafter, 2 or 3 years, I find that this compound is already known because this is isolated from CDRI Lucknow or some other institutes and structure is established. So whole work has no value at the end of the day. What is research? Research means search followed by research. It is not the research followed by search. But you see, you ask your faculty members, whether you are submitting any project to the funding organization, you are going to search and then make your project and submit that project for funding organizations. Very few faculties are doing like that. But in the foreign countries, I have seen in my foreign countries, before taking into any project work, any research work, thus they are going to search, not the non-patent literature document. In our time, we are searching and review, we are doing with chemical abstract. That is the non-patent literature search. But the patent search is required because 70% of the technical, commercially technical information is only available in patent document. And thereafter, it is coming as a publications in non-patent literature. I have a lot of examples also. Thus, if you look at the television technology, TV technology, when first filed in the patent applications filed by the Japanese company, television technology, and thereafter 5 years, it has come to a magazine and journal, the television technology. So, punch card. After 25 years, that this has come as a non-patent literature, as a document. So, lot of things are there. So, my request is before starting any project work, you must go on the patent database search because patent application has to be filed at the very early stage of invention to protect the novelty and the inventive step of the inventions. So now I am coming to the invention. This part I will not address because already Dr. Banerjee has addressed in the morning sessions. This will be new product and the new process involving an inventive step and the industrial application. And there novelty means, newness means, here the global novelty. What do you mean by global novelty? Global novelty means not prior to publications, no prior publications, no prior claiming, and no prior use. These 3 things should be there. Then it will be considered as global novelty. So, your application, your product, your process should not be used, should not be published, and should not be claimed. as well as it should be non-obvious in nature, and that non-obviousness would be judged by the person skill in the art, not by the ordinary person. That means the person skill in the art should be acquainted with the technology. Then only we can say it is non-obvious, and their application should pass the test of the industrial applications. Now I'm coming to the certain inventions are not patentable. My previous speaker in the second session has already stated that certain inventions are not patentable subject matter. In case of our pharmaceutical research, I am saying that section 3D is very important section in our patent act, because that section is saying that the mere use of known substance is not a patentable subject matter. Section 3E is saying mere admixture is not a patentable subject matter. And also section 3P, that is the traditional knowledge related any product, is not a subject matter for patent. So you see one important thing, that if you make certain incremental innovations, what is doing by the pharmaceutical company or the giants in the pharmaceutical sector, they are always going for evergreening the right. Within the mother patent, based on the mother patent, they are creating number of child patent. Why I am talking about child patent? Because child patent will protect the mother patent, so that nobody can enter into that mother patent even after the expiry of the term of 20 years. But that means it is called the fencing. And how they are creating child patent? By making derivatives, salts, polymorphs, esters, nanoparticles, particle size. In that way, they are protecting their blockbuster molecules, so that they can extend their term even after 20 years and enjoy the monopoly of right. This is called evergreening. In Indian law, section 3D says preventing those kind of child patent for the grant of the patent, because of the reason that there is no surprising benefit. Yes, if you can prove the surprising benefit over the mother patent, after making the child patent, it will be allowed. But in very few cases, I have seen in my life that they are creating the child patent only to evergreening the right. Even the synergistic effect, already mentioned in my previous speaker, that even a mixture or a formulation, if you can prove that it is a synergistic effect there, then only it will be subject matter for a composition, otherwise not. Because I'm giving the example of the ampicillin cloxacillin or amoxicillin cloxacillin has a synergistic effect. But ibuprofen paracetamol combination or diclofenac paracetamol combination has no synergistic effect. So it is not a subject matter for a new patent, another patent for that. So lot of things are there. So I am not going the method of treatment of human beings. In USA it is patentable subject matter, but in India it is not a subject matter for patent. How physician will take the steps for the treatment of the disease of a particular patient, that cannot be monopolized under the law. For that we are not giving any right to that. So method of treatment. So I am not going detail. Already this portion is addressed by our previous speaker. Now going to file patent application. My previous speaker has already mentioned that before any publication, any communication, you must file the application, at least provisional application, and then you communicate to your funding organizations, or to any poster presentations, or to any publications. But here I want to mention, or I want to add one more thing, that we have the provisions of the section 29 to section 31. These three sections categorically mention that before filing patent application, if you disclose the invention, still it will be considered as a patentable subject matter and novelty will not be destroyed. But that is called the special provisions. I know very recently one patent was granted on an application which is already filed before filing patent applications 6 months before in nature. And we have allowed it. Why? Because section 29 to 31 is saying that if you present any publications or your work to before any learned society, then you will obtain 12 months grace time to file your patent applications. So in that case, 12 months grace time you cannot, say for example, you have presented one paper in poster presentations, or you have presented one paper before any learned society or an international symposium or international exhibitions. So in that case, within 1 year after presentations, if you file the patent application, that application will not be anticipated by your prior disclosures. This is an advantage for the academicians, for the research scientists who are facing this kind of problems. Yes, publications or disclosure is very necessary, very urgent, then you can publish it. But within 12 months, you have to file the patent application, then it will not be considered as an anticipatory document. Now I'm coming to the specification. Contents of specification is very, very important, because certain prescribed form is there. Prescribed form, your attorney can take the steps how to fill up that form. But the drafting of the specification is an art. I find in my life in many professors of many renowned universities, I am not mentioning the name of the university, can write very good paper, but cannot write patent specification, because it is a techno-legal document. You have to write the specification with technical language in the eye of law. So the techno-legal document, and particularly the claim of the specification, is very important. I have seen in my life that a very good invention of one university in India has turned to a very bad patent because of bad drafting of claim. So narrow and restricted claim they have made. But a small work has turned to a very good patent, strong patent, because of good drafting. So it is a skill, and that skill possessed by our patent attorney friends, or some professionals are there who can draft the good specifications. And their charge may vary from any point of time, from 10,000 rupees to 2 lakhs rupees also. It all depends upon what is the nature of the inventions. So I don't want to spend more time for that. I can give you example if you possible in other forums or in other time. Now, another important thing, why I am talking about the patent cooperation treaty now, because many things are allowable in India. Section 3 is there. We are not giving number of inventions which are coming under the life form in biotechnology. So in that case, whether our scientists who are working in the field of biotechnology will not get any protection in India or in the world. So in that circumstances, I will recommend those scientists don't think about Indian patent. You file application in India. If it is rejected, okay. Based on that application and the priority date, you can file the application in the countries other than India. But we have joined in 1998 the patent cooperation treaty. Before that, what happens? Every country you have to go and file the application, select the attorney, pay the prescribed government fees, and lot of prosecution you have to face to obtain patent in different countries. But that has been reduced through this patent cooperation treaty, and we have joined. And by a single international application designating different contracting countries, if you want to do business with your technology in say 5 countries or 10 countries or 12 countries or all countries, 152 countries, so you can apply, you can designate and can file the application to protect the invention simultaneously by a single international application filed in Indian Patent Office. As because you are in Kolkata, so Indian Patent Office, Kolkata office, you can file this application either by e-mode or by physical mode. But you keep in mind that it is a patent filing system. This is not a patent granting system. As of today, we have no international patent. We have no world patent. If you want to protect your inventions in the countries other than India, then you have to obtain patent from different countries according to their laws. So it is called the international filing system to protect your invention, to protect your priority date, so that novelty will not be destroyed. So the filing in a single office in one language having the effect in each contracting state. So now you see the patent representative who file the application to protect your invention in the countries other than India, you can protect your invention simultaneously in all the member countries under patent representative. And also you can have more decision time. Why? Because whether I will obtain grant of the patent or not, that decision you have to take within 12 months of time after filing, after publication of the application in the Patent Office Journal, because you have to file a request for examinations, and that request for examinations to be filed within 48 months from the date of filing of the applications. That is from the first application, that is the priority applications. So, but here when the national phase entry is made after 31 months, that means more than 2.5 years after you are entering into the national phase for the actual grant of the patent from different countries. So you can have 2.5 months time instead of 12 months time after filing these applications. So you can understand also the strength of the invention, because whenever you file the international applications under PCT, your application will be searched by the International Search Authority and International Preliminary Examination Authority, and you can obtain a search report. Say, for example, your search report is very bad. It lacks novelty and inventive step. So in that case, you can amend. You can get the opportunity of amendment of the applications in the examination stage and preliminary examination authority, and then enter into the national phase with the full strength of the novelty and the inventive stage, so that your application will not be rejected in the national phase when actual patent will be granted by the different contracting countries. And also by that time, when your application will be published in the PCT Gazette, that is published from the World Intellectual Property Organization in Geneva with the search report. And then that report, after when it will be published, all the interested persons working in different parts of the world will see your invention, and they will offer you to assign the right to them, and they will do the business and pay you the royalty in dollars. So you will have the opportunity to have the foreign counterparts also by way of filing international applications. And most important thing is that because we are the developing countries, 90% rebate of the fees for the natural persons in India. For the institute, there is no rebate, but for natural person, individual person, if apply international application, then 90% statutory fees cannot be paid to them. That is the International Bureau of World Intellectual Property Organization. This is a big opportunity for the natural person. As well as I can say that now Indian Patent Office is recognized as an international search and international preliminary examination authority, and only they are charging 10,000 rupees search and 10,000 rupees examination fees. And this is lowest fees all over the searching authority lying under PCT, that is the Patent Cooperation Treaty. So now I am coming to the product rating. We have seen that 2005, 1st January, a major change has come, particularly in the pharmaceutical sector. And product regime started from 1st January 2005. What product regime covers? It covers the pharmaceuticals and agrochemical products. It protects it is giving the chemicals produced by the chemical process or the biochemical process, and the microorganism per se, that is called the naturally occurring microorganisms. So all the three things covers under product patent and to be granted as a product. So now, what is the problem? If you look at the problem, that it prevents reverse engineering. You cannot touch that product for 20 years till the monopoly will be finished. So reverse engineering to produce the patented product by different process will not be possible. And the research and development activity for development of the patented product at reasonable price and availability will be in question. So that means reverse engineering is discouraged in the product regime, which is not available during 70 to 95. Only process patent was there. So anyone can do make the product by different process also. But in the product regime, you cannot touch the product for 20 years. And then is that the company has to be forced to go the license agreement or the compulsory license system with the patent holder by paying the reasonable royalty. That means automatically they have to bear more cost for that to take the technology. Now, what is the reality? Because many few companies know about the to use patents as business. Very few companies. So first hurdle is the unevenness in domain knowledge of patents, and unrealistic defense mechanisms are taken by the pharma companies against the global norms, and it is a most critical challenge in the product regime for the pharmaceutical industry, Indian pharmaceutical industries. So Indian pharma industry, I feel so, has to gear up and to face the new challenge, because we have the huge natural resource and other resources, human resources we have. So excepting a few companies, most pharma sector are unfamiliar with the complex patent prosecution strategy, which is called the PPS. Strategy is very important to obtain patent and to commercialize the patent right. So R&D based sector having the first hurdle knowledge and the successfully design and implementing the sophisticated PPS system. So this is the reality. We cannot ignore that thing. So the why the product patent regime introduced in India? If you look at the drug discovery status, if you look at the investment status in R&D by the industries and the other agency, the 25% investment we are making on drug discovery and 75% on the drug development. That means already some blockbuster drugs are there. We are going to make different drug delivery systems already. And absence of data exclusivity and no product patent before 2005, most of the companies are very far away from research and development, particularly in the pharmaceutical sectors. So when they have seen, no, we had to face the challenge and we had to create our new product, new process, everything. So they have now started the investment in R&D in pharma sectors. So 15, if you look at the statistics, that the 15 new drugs approved by USPTO in 2020 compared to 5 years average of 31. That means the new drug discovery also reduced from 31 to 15 per year, and forcing the R&D fund to market the existing blockbuster products. And if you look at the annual drug discovery technology highlights, this is 1970 when for 18 new molecule entities we are spending $50 million. In 2020, for one new molecule entity, we have to spend more than $2,500 million. So it is very difficult to spend huge amount of money because failure rate is very high. So the resolution has taken that hard to conceive how such excessive of expenditure can be sustained in future, and so new tools and methodology are required or needed to improve the success rate in face-to-face trial. Most of the drugs fail in face-to-face trial because of toxicity or the undue effect. So now coming to the strength, we really want synthetic medicines, or we can go for some alternate medicines which can address the treatment for the different disease in India or the neighboring countries. If you look at the strength of India for development of industry, we have the potential natural resource, traditional knowledge, skilled manpower, and domestic and global market. So if we have, we see our natural resource, that we have leading biodiversity countries in India. 45,000 plants, 16 agroclimatic zones, 25 biotic province, 426 biomass, and 7,000 to 7,500 medicinal plants used by our traditional communities, and 40% of the total medicinal plants available only in northeastern states. So 130 pure drugs referred in our Indian pharmacopoeia, isolated from 100 Indian species. So if we look at the traditional knowledge of ancient books, we know these plant materials are used for the treatment of different disease. So we can go for target approach instead of the random approach for isolating the molecule and formulations and making the product available to the public at very low cost, and substitute our synthetic Western medicines also. And we have the world's second reservoir of scientists and skilled manpower. And for that, government has created a TKDL database, traditional knowledge digital library, to for documentation, for the purpose of documentation of all the medicinal plants for which it will be, for where it will be available, and what is the method of treatment of those plants, what part of the plant will be used, what is the active components are there. So all the things are properly documented in integrated database. And Government of India, to maintain the biodiversity and the bioresource, also introduced the National Biodiversity Authority under the BDA Act, Biodiversity Act. And also Section 6 of BDA Act is saying that before granting any patent on the biological materials available in India, you have to take approval from India. And also, as because TRIPS has said, plant will not be available, plant will not be available as patent. So you have to create a separate laws to protect the plant, because there is a huge investment in India, because India is basically an agricultural country, and ICAR is doing a lot of research and spending fund for different hybrid plants, hybrid seed, and so on. For that, we have created a system which is called the sui generis system, and we have created the plant protection of plant varieties and the farmers' right to protect the new varieties of seed and plants also. So now I am going to the demand. If you look at the demand, we have the demand of $320 million in global market and $100,000 million in INR domestic market. So WHO recommends that herbal drugs in national healthcare program should be introduced, and 40 to 50% of the health budget on drugs will be reduced if we can start of using natural product, the herbal medicine instead of the Western medicines. So developing countries can take part major role for their economic development. But everything is possible if we go on the ethical considerations. Pharmacy and pharmaceutical technology is such kind of subject. You are the person just after doctor, because you are manufacturing medicine and doctor is prescribing your medicines. So proper ethics should be maintained at the time of manufacturing, analysis, and also in practice. So research, clinical trial, pharmacy practice must be carried out with utmost ethical consideration, at least not to cause any harm and to the participants to provide the quality pharmaceutical care in society. So it is very obvious that pharmaceutical research, including clinical trials in human pharmacy practice, is getting in prime importance. We have now introduced under the drugs and cosmetics standards the GMP, GLP, Schedule M, Schedule A, lot of things are now. So you see, the Patent Act is not the only act which can give you all the right. Patent Act is giving you the negative right. That is, you have the right to prevent others, not to manufacture. But when you are going to manufacture that product, you have to take permission from the Drug Control Authority to obtain manufacturing license for manufacturing, selling, and distributing that product. So ethical considerations and the provisions of the drugs and cosmetic standards rules should be followed properly. And I am not going to detail the ethical principles, autonomy, non-maleficence, beneficence, justice, everything should be followed properly. And it is the general pharmacy practice and ethical examples, a lot of ethical examples are there, observation studies, analytical studies, clinical trial. And this is very important for the development of new molecule or old molecule in new treatment, new way of treatment. In every step, the ethical considerations, clinical trial are getting primary importance whenever you are selling the product in the market. But everything is possible. Everything is possible when you can create a good network. Because certain knowledge reside in academia, certain in research institutions and industry. It is not possible to create all the knowledge under a single umbrella. So when you can create this network with the brainware in the industry, academia, collaborations, and also the research institutions, then only you will be the successful entrepreneurs, successful scientists, and you can bring good product for the treatment of different diseases. Ultimately, it will give value to the economic development of the country and the society. But transfer of technology, another important area. Whenever you produce the product, you don't know who will buy your product. So for that, the patent information system is required, because who will be your customer, that you also can search before starting any project. You can go for collaboration with that companies. And before doing any research work, getting surprising result of your product or surprising result of your research, you can go to collaborations and ask for fund and give the license to them through patent assignment or license agreement, and the trade secret part you can share with that company under confidential agreement. When both the things will be made under the Contract Act and the Patent Act, then only fully technology transfer are possible. Otherwise, it is very difficult for transfer of technology, because certain things in the patent specification is not disclosed by the applicant, I am telling you. And this is the art of writing. I have disclosed everything, but not disclosed the major areas from which you can have the hint to make the product. So that is covered only the trade secret part. So whenever both the things will be made, then only you can manufacture that product based on that disclosures. So now the thing, everything is possible. My previous speaker was patent attorney. He has said, on behalf of inventor, applicant, we are doing this work, the drafting and also attending hearing, and when the patent office will raise the objections and issue the first examination report, and after grant, payment of renewal fees, license agreement, and if any opposition, because it is not that you will not face any opposition. Opposition can enter in your application for and raise the objection that patent application should be rejected and it will not be granted. So to face the opposition also, the attorney friends can help you in the hearing and to submit the documents and written submission in such a way that they can cross the barrier of the opposition's objections also. And so the patent attorney, any student without law degree can work as a patent attorney. And this is the only area where patent attorney can work, the legal work can do without any law degree. But you have to pass the test of the patent agent examination conducted by the patent office, then you will be recognized as a patent attorney, and you can work on behalf of the inventor or the applicant as a patent agent and can appear before controller for the grant of the patent and for any stage of prosecution of the patent applications. So the conclusion part is that we have now gone from limited term of process patent regime, 7 years, 5 years, to product patent regime of uniform term of 20 years. And far reaching implication and translation will become evident in the years to come. In the meantime, IPI, that is the Indian pharma industry, should gear up and to face the new challenge, how to manage their IP portfolio. And efforts to achieve parity of knowing the rules of the game confined in India, because it is a territorial right. If you want to do business, you have to know the rule of the game lying in India, and sooner or later, I think already from 2005 to 2022, 17 years we have passed. So already we have learned a lot of things, and we know how to transform our knowledge-based sector capable of producing research-based medicine at affordable prices to Indian people. And with this knowledge, you can go for the research on our natural resource, herbal medicines, herbal drugs, and a lot of scientists now working in the research of the herbal medicines and the herbal products because of knowing the side effect of the synthetic medicines also. So it is a great opportunity for the Indian scientists that we have different varieties of medicinal plants available in different geographical locations from where they can collect the sample and can do the research work and can address the problem. So the last suggestions that you must consider the benefit of the patent system. Don't go for publication first. First, to try to protect your invention, either provisional or complete specifications. Even after publication, you can file, I am telling you, within 1 year, but you have to file the applications and utilize your human resource, natural resource, mineral resource, all the resource through organized R&D activities. And our market is very big, very big. Why I am telling? Because in India, domestic market is there, and we have the Southeast Asian market, where they have no capacity to manufacture pharmaceutical product. We are the suppliers of pharmaceutical product to the Southeast Asian countries also. So we have the global market also, and try to protect your product through patent and earn profit through protected market. Because if you do the work and don't know someone has already filed the application, then tomorrow you can have the legal notice or the caution notice in the paper that you are infringing my right and you have to pay compensation for that. So don't do like that. You first protect and then follow the technology and carry out the business. If your patent be rejected also, don't wait the monopoly of right, but still you will be recognized as because your patent application is there, published. It may not cross the barrier of the novelty inventive state, but you are you have filed the application, and based on that you are filing the product also. So I believe that you have understood what I want to mean in my presentations within a short period of time, and thereafter I say the patent and public policy. Patent is a pot of gold, no doubt. If one patent click, we will be a very rich man. Out of 20 patents, if one patent can click, then you will be very rich man. But when you think about public policy, public health issues, government policy, and also the opposition, infringement, revocation, court, so you can face the tail of wolves also. So, but don't worry, you must be smart enough to file applications and protect your inventions. Those in every step of life. It is not that it is only in your research field, in every part of life. But you have to know the rule of the game, how to avoid those. Thank you everyone for this lecture.
Thank you, sir. So I would like to request about participants to ask if anyone having any question to sir. And,
Please, Brahmaji, chairman is there.
Prashanta sir is also here. Sorry. So, Prashanta sir, if you want to ask, then you can ask.
Chairman of the session is to conduct.
Okay.
Thank you, Dr. Mitra, for your excellent and informative and valuable presentation. So it was extremely helpful session for our audience. So now I would like to request our audience to ask a question to our speaker. So you can directly ask the question or write it in the chat box.
Thank you. My question to Dr. Mitra is that first to file cases or first movers advantage. First to file cases or first movers advantage. What type of exclusive marketing rights, EMR, we can enjoy?
Actually, that provision is repealed. Exclusive marketing right provision only lying within the transition period from 95 to 2005. That provision has been repealed by 2005 Amendment Act. And that right is given only to market, not to manufacture the product. But patent right is the manufacturing right, marketing right, distributing right, all the rights. But EMR, exclusive marketing right, is only for the marketing right, and that right is given for the transition period of time from 95 to 2005. And when the Patent Amendment Act 2005 has come into effect from 1st January 2005, then that provisions of EMR has been repealed, has gone.
No, then after 2005, if such discovery is made and then it is filed as a first to file case, then what is the benefit the discoverer or the inventor can expect? Either in terms of
after 1st January 2005, if you file one applications which claims product and process both, then if it satisfied the novelty inventive step and crosses the barrier of section 3 and 4 of the Act, will be allowed for registration. That means the patent will be granted as a product patent and process patent. Now, one important thing is that the patent claim is a claim where you have to maintain the single inventive concept. That is very important. One patent for one invention. One patent only covers your product, your process, and your application. But separate application will not be allowed. That application will be merged with the product. Say, for example, you are to claim the product, say A, used for treatment of such and such disease. That means the application will be the leg of the product. Understand my point?
No, I didn't understand because you have told in your last exhibit that earn profit through protected market. So suppose if a company or if a university or if individual discovers or innovates, invents some product or process, and if he is successful in getting all the barriers which you are telling, which are very basic barriers, it is applicable to all cases of patenting, then what financial profit or what financial earning that company or that
Financial
individual can.
earning, you are to license. You are to license with the company.
No, that is there. But question is, I'm asking that in some cases, 180 days exclusive marketing right has been given, which we have also enjoyed while in industry.
No exclusive marketing as a right is given through grant of patent, and if you want to earn money as a royalty, so you are to assign or you are to license the right to the company who will manufacture the product with your technology and pay you the royalty according to the contract agreement.
No, the company who develops this, he will not get any benefit. He will not get any financial reward. You mean to say
Now,
exclusive
company,
marketing,
no,
exclusive marketing right.
whether the invention is made in the institutions or in the company. First you tell me.
No, so that's what I'm asking. Exclusive marketing right, when it is given or when it is assigned to the company, what type of exclusive marketing right you can tell us? Because we have got that experience. I can tell you, but I want to know your opinion.
I am telling you that exclusive marketing right is provision is not there now. Only we have the law patent right, and patent right includes the manufacturing right, selling right, distributing right, every right. But that right is a negative right. You have the right to prevent others. Understand my point? You
No,
have
I'm
the
not
right.
understanding. I'm not understanding because unless and until I get the correct answer from you, I cannot understand some wrong approach. It is not the case. Company has to get some financial benefit. We have got. Our experience has told we have got one company who has developed some piperazine and tazobactam combination and got into the market for the first to file case. They have got the exclusive marketing rights of 180 days, that is 6 months, solitary marketing benefit. No other company can market that product till that 6 months period. This is known as exclusive marketing right, Dr. Mitra. We have already got this. So no doubt. There should not be any doubt when a person is telling he has enjoyed that benefit. There should not be any doubt. And this is known as exclusive marketing right, which is extendable only for 180 days till granting, from granting.
Under what provision? This provision is not there in the law.
Which law?
That provision is not in the law.
Then how it is being given and how people have enjoyed? I'm telling it is already done. It has already enjoyed. The benefit has been already given.
You are saying that after the grant of patent, 6 months exclusive marketing right you have, but that provision is not there.
How it is possible? If provision is not there, then how people are getting? It must be there. It must be there.
Okay, sir. I think our this session is getting delaying. I think this matter, I think both of you can discuss or through some email or some other way.
Wrong communication should not be there because it's an important national webinar. Here, no wrong communication or half true communication should not be there.
It's okay.
Why can't we consider that the law is subject to change? Why don't you consider that?
No, if that law is, definitely the law has been changed. That's why it has been given. I'm telling you. The companies or the scientists who are working on behalf of the company, they have already received. I'm one of them. So I cannot accept some hypothetical answers.
But
it is there. And I'm telling you.
May I ask, what was the time? When was it that it happened that you got the exclusive marketing right?
Year you're telling. Year.
So, sorry for interruption. Actually, these things can be solved
Yeah.
in personal way. So I think our
No,
time is also
it should not be like that.
it's
It's not
very
the, in
precious.
the Indian law. That's why I am asking. Anyway, okay, go ahead.
Yes, continue, Dr. Samarji, sir.
Yeah, and Dr. Mitra, I have one question. Actually, how our scientific community and industry personnel will judiciously utilize the large number of patents available in patent database for commercialization? Can you please explain?
How the scientific communities? How
How
the
our
scientific
scientific community and industry personnel will judiciously
Uh,
utilize the large number of patents available in the patent database for commercialization?
actually you have to go and search on a particular product. If you are interested to manufacture a particular product, you have to go and search that particular product, and then the number of documents will be coming our Indian database, and you can go a individual search what is the technology, whether it is a process technology or a product technology, and what is the validity of the patent, whether the term is over or not, or has become ceased. So with all the information you can have from our database, and from database you can have the idea, and then you can proceed further for manufacturing that particular product if it is a off-patent molecule, or if it is not a off-patent molecule, it is a patented molecule and it continues with the payment of renewal fees, then you have to go to the patent holding companies for transfer of technology through license agreement or the confidential agreement, and can manufacture that product. Understand, right?
Okay. So with this, I would like to hand over the session to Mr. Srijan Martin.
Okay, thank you very much, sir. It's a pleasure to give a vote of thanks on behalf of the Department of Pharmaceutical Technology and Department of Biotechnology, Brainerd University. I'd like to thank all the dignitaries present today on the webinar Intellectual Property Rights and Industry Academia Collaboration, organized by Department of Pharmaceutical Technology and Department of Biotechnology, Brainerd University. I'd also like to express my heartfelt gratitude to Dr. S.K. Mittal sir for sharing his insight on patenting in pharmaceutical academic institutions. I'd also like to express my gratitude to Dr. Samarjit Ray sir for giving his valuable time to us. And last but not the least, a very special thanks to the member of the organizing committee for creating such a wonderful knowledge sharing platform. I must thank all the faculties of the Department of Pharmaceutical Technology and the Department of Biotechnology, Brainerd University, who has worked tirelessly to make this event possible. Thank you all for making this session a grand success. Thank you.
On my behalf also, I just thank Dr. Mitra.
Yes.
Dr. Mitra, you have accepted our invitation, and your speech is very good and very useful for academic, and you are also in the academic and industry and other things are there, and you are also staying nearby and involved with the Adamas and Brainerd, not far away also. So I think in the future days you will be very helpful to our department or biotechnology department and others in this Brainerd University. Thank you very much, and we are very happy to listen to your lecture also.
Thank you, Dr. Bhatti.
Yeah. Yeah, Brahmajit.
Yes,
I
sir.
think this, Sritama madam is there. I
Yes,
think,
sir.
yeah. You
Okay.
go to the next.
Okay, thank you, sir. Now I would like to request Dr. Situma Desharkar, Madam, Assistant Professor of the Brainerd University in the Department of Pharmaceutical, in the Department of Biotechnology, to take the session. Ma'am, it's over to you.
Yes, thank you, Brahmajit. Good afternoon, everyone, and we have come to the last scientific session of today, where we have Dr. Manish Kumar Timaraju as our eminent speaker. This session will be chaired by Dr. Proshenjit Mondol, Associate Professor, Department of Pharmaceutical Technology, Brainerd University. Before handing over the session to Dr. Mondol, I would like to introduce him to our audience. Dr. Prosenjit Mondal has done his PhD back in 2017 from Jawaharlal Nehru Technological University, Hyderabad. And after that, he had been an associate professor and head of the department pharmaceutical chemistry at Bhageshwari Institute of Pharmaceutical Sciences, Telangana. He has over 64 publications in prominent national and international journals, and he has been an active reviewer in few of the prominent journals as well. He has 2 Indian patents, one in fluorescent chemical from Banana West and another in as a nanoparticle based topical composition for inflammatory skin conditions, for treatment of inflammatory skin conditions. Without wasting any more time, I would hand over the session to Dr. Mondol. The session is over to you, Dr. Mondol.
Hello, am I audible?
Yes,
Yeah.
yes, sir, you are.
Yes. Okay. Thank you, Dr. Sridhama Sarkar, madam, for your nice and thorough introductions about me. A very good afternoon to everyone present in this national webinar. Myself, Dr. Prosenjit Mondal, Associate Professor, presently working in the Department of Pharmaceutical Technology. I am welcoming to all of you in this today's online national webinar on intellectual property rights and industry academia collaboration. Our previous speakers has already provided enough information about the intellectual property rights and patents and everything. So therefore, without wasting time, I would like to introduce today's speaker for the enlightenment more in this area. And this is my privilege to introduce today's speaker in this session, Dr. Manish Kumar Thimmaraju. So Dr. Manish Kumar Thimmaraju completed his Bachelor of Pharmacy from SPCP under the Osmania University, Hyderabad in the year of 2003 and finished his master's degree in pharmaceutical analysis in the year of 2006 and received his doctoral degree from Acharya Nagarjuna University, Andhra Pradesh in the year of 2014. He started his academic career from 2016, worked at various pharmacy institutions and presently working in the Balaji Institute of Pharmaceutical Technology, Warangal, as an head of the department, pharmaceutical analysis. Over this vast teaching career, he published more than 50 research publications at various national and international level with reputable impact factor. So he is the author of 5 academic books. He had 7 Indian patents and 4 Australian patent and 1 South African patent in his credit. Dr. Manish received the research grants from various SERB DST twice, and he also received the Telangana Academy Science and Tuberculosis Associations of India some grants, and he is the recipient of various awards like Young Academy of India Awards, Teacher Innovation Award, Young Researcher Award, Inspirational Association Awards, and Shiksha Shri Award from the various recognized organizations. He attended 23 AICT sponsored quality improvement programs, 20 national and international conferences, and delivered his talks as an invited speaker in 12 national seminars. He is the life member of APTI, that is Association of Pharmaceutical Teachers in India, and IPA, that is Indian Pharmaceutical Association. So thank you, sir, for accepting the invitation as a speaker in this webinar. So I heartily welcome Dr. Manish Kumar Thimmaraju in this session, and I request to deliver his speech. Over to you, sir.
Dr. Manish, welcome, sir. Dr. Manish Kumar.
Sir, you are muted, sir.
Dr. Manish Kumar. I think
Sir, please unmute yourself.
Dr. Manish Kumar, please unmute.
Sir, is it
You are-
clear now? Is it voice
Yeah.
audible?
Welcome, sir. Welcome.
At the outset, I would like to thank Dr. Bhakti Bhushan Barik sir for inviting me for this lecture in national webinar. And I would like to thank Prasanjit sir for his kind words introducing me. And coming to my presentation, I'm share it. Prasanjit, can you share my presentation?
Okay, sir. Sir, wait 1 minute, sir. He's.
So I'd like to say one thing, sir. Most of the things what I'm about to say are being dealt by all the eminent speakers. So I think uh, it will be a repetition, all the topics which have been already discussed in the morning, especially Vijay sir, Ambika sir, and Sushil Kumar Mitra sir. The topics have been very much uh, thoughtful, and so when I compare my presentation, it will be a repetition. So I directly go into the topic. So my topic is insights of Indian patents. Sir, can you move the next slide? So briefly, I will recap or rebrush all the topics which have been dealt by eminent speakers previously. So IPR are legal rights which are granted to a person for creations of mind or intellect which have commercial value. So they are intangible, as the word itself says. We have different types of IPRs. Next slide, please. We have patents, trademarks, copyrights, geographical indications, industrial designs, and trade secrets. So these are all being initiated from the mind. So today we are going to concentrate more on this patents. Next, sir. So coming to IP laws of India, we have the Patents Act in 1970, which was amended in 2005, and the patent rules have been initiated in 2003, and the Design Act is in 2000. The design rules in 2001 as amended in 2008. The Trademarks Act is in 1999 and trademarks rules were implemented in 2002. The Geographical Indications of Goods Registration and Protection Act in 1999 and the Geographical Indication Goods Registration Protection Rules in 2002 and the Copyrights Act in 1957 which were amended in 1999. Next. Next slide please. So coming to organization structure of various IP offices in India, so which comes under Ministry of Industry and Commerce. So we have different branches available, and coming to designer wing, we have it design wing at Kolkata. Patent offices, we have main head office at Kolkata and other offices at Delhi, Mumbai, and Chennai. And coming to trademarks registry is at Kolkata, Delhi, Mumbai, Ahmedabad, and Chennai. And geographical indications, we have registry at Chennai, and patent information center or service we have at Nagpur. So depending upon the jurisdiction of the filing of the inventor, we need to choose the office. Next slide. So coming to how these IPRs for students and researchers are useful. So the main aim of filing a patent or any other intellectual property right, the main is to prevent duplication of work and help researchers to focus on commercially relevant research and prevents from exploitation and helps in revenue generation and prevent from infringements and stimulate creativity. If you give an example under prevent of duplication work, for example, if a researcher working in probiotic area or in preparation of probiotic formulations, so under the guidance of his eminent supervisor, they have been toiling in the laboratory for more than 5 to 6 years, and they have come up with a good formulation, and they have completed the thesis, or whether it may be master's or PhD thesis, and they have presented the same work in, for example, they have presented in any conferences. So in the conferences, they may interact with the networking of any manufacturer. So suppose they have been interacting with a manufacturer who has been more interested in probiotic manufacturing or preparation of probiotic formulations. So they may interact together. And if they have any memorandum of understanding between them, if the researcher or the supervisor doesn't have any prior information about their work in proper searching, because most of the researchers, they do or they start the research work in regular literature review, so they sometimes they may ignore the patent search. So improper searching of work may have a duplication. So that may be work, maybe some other country may have been registered the same work. So the whole work which has been invested during this will be wasted. So searching properly the patent database will always help in preventing the duplication. Similarly, help the researchers to focus on commercially relevant search. So this patent search helps the researcher to focus on what is hot rather than which is not irrelevant. So by searching in patent search database which is relevant to the market, they can go for commercially and they can synthesize it that way, and prevents from exploitation. Suppose, for example, we have an analyst is working in chromatographic area, so he has been using a column which is which results are not reproducible. So the person or the researcher who is involved in this research comes up with a novel change in the stationary phases. So he may come up with the idea that some changes in the stationary phase may enhance the results. So if the person is not able to patent the work in changing the modifications in the stationary phase, if he approaches an industry, that may be exploited. So in the same way, if it is being approached by right person in the industry, so he can get revenue by patenting the whatever the stationary phase has been recovered, and it also prevents some infringements. Next slide. So coming to the topic patents. So patent is an exclusive right granted by the government to the original inventor of the invention, which prohibits others from making or using or selling the invention. So duration of the Indian patent is quite long, that is 20 years. And so the inventor can enjoy the fruits of this work for 20 years. Next. So what is patentable? For patentability, as invention must satisfy three basic criteria, which should be novel, non-obvious, industrial application, and which cannot be patented. As the earlier speakers has clearly mentioned, inventions pertaining to atomic energy cannot be patented. Something which is frivolous, contrary to public order, and harmful to society cannot be patented. And methods of agriculture, horticulture, medical treatments, plants and animals in whole. So these cannot be patented. So this is a patent grant certificate of my work, which has been received in 2017 on my work, that is formulation, pharmaceutical composition for treating cancer through nano emulsions. So which I have received the grant. So this is a certificate. Next slide. And coming to the trending of patents worldwide, this is I have taken from WIPO. According to the WIPO, there are 137 lakh patents in force worldwide. Here is a breakdown of top countries. United States stands around 29.8 lakhs in filing the patents. China 20.9 stands in second place. Japan 20.1 lakhs. United Kingdom 12.4 lakhs, and Republic of Korea 9.7 lakhs. Trending in India. So we have grant of patents during 18 and 19 rose 12% due to various measures taken by the Commerce and Industry Ministry to streamline patent examination process. So incentives as given by the Government of India. So there was a rise in filing of patents. So 28,000 patents has been filed, in which 3,138 were design of registrations. Next. So this is the individually and through firms, universities, government organizations, hospitals and institutes. So this 23,000 has been categorized individually, university-wise, government institutions, hospitals and institutes. So this is a trending of India in 2018 and 19. Now, what is the difference whether we need to go for a patent for your research work or a publication? So public disclosure may harm your work. So as Vijay Kumar sir and Mitra sir has said, we need to go for patent before publication. So once if you have published your work, which has been very much relevant to society, if you are disclosing it out, that you may lose the rights on it. So the best way to publish a publication or an article after filing a patent. So why the reason behind researchers prefer publication over patent? So the main, the proverb that publish or perish. I'm not going to say the reason behind, but many universities are pressurizing the researchers to publish as it gains a reputation to the institution. So they prefer more publication. Why? Because publication has a detailed work, the searching portals will be elaborate, where patent search is very narrow. Unless until we go to the respective patent offices website only, we are able to see the innovation which is presented by the inventor, whereas a publication can be seen freely on a web. And one more thing is that most of the universities and colleges doesn't have any IP facilitation center where the how to approach and how to file a patent, what are the forms and what are the legal issues to be treated. They are not aware of that. So these are the main things. These are the hurdles why most of the researchers preferring publication over patents. So once a IP facilitation center is set up in any university, that may help the researchers to go parallelly filing a patent as well as a publication. So the take of this advice is to have a publication after filing a patent. Next. So this is a schematic way of the journey of patent from filing stage to the grant. So when you have invention in your mind, so go for provisional specification, that is just write down a few points on your research and just go for provisional specifications where you can register your invention. Exactly after 12 months, within 12 months, when you go for complete specifications with your results, so then you can go for the next step for publication. So the time taken from complete specifications to publication is 18 months. From after 18 months, it will be moved to further examination by applying to the patent office with a specified form as a request for examination. So that is FER, that is first examination report, raises any objections on your work, so that can be cleared, and filing the reply, or the grant will be issued through hearing process. So after getting grant, you need to pay a renewal fee for over a period of 20 years. And if you are not paying the renewal fees, they get seized. So this is the journey of from patent filing to grant. Next. So important timelines during the prosecution of patent applications: filing of complete specifications following provisional specifications with the Form 2. Within 12 months of filing the provisional specifications, we need to approach for complete specifications. And statement and undertaking regarding foreign application, that is form number 3, within 6 months from the date of filing of application. A request for examination, that is we need to use form number 18, where it takes 48 months from the date of filing and priority whichever is earlier. Declaration of inventorship, that is form number 5, with the complete specifications within 1 month from the date of filing of the complete specifications. Time for replying, that is FER, 6 months from the date of issuance of FER, extended up to 3 months. Total 9 months time is given for raising your concerns regarding your first examination report. And pre-grant application, that is form number 7A, after publication of the application and any time before the grant of patent. Post-grant opposition, 1 year from date of publication of grant of patent. So this is the timelines of patent application. So this is the publication which is being issued by the patent office after 18 months of the complete specification. So it gives the title of the invention, application number, the inventors, applicants, and abstract with the claims. So this is a publication of a pharmaceutical composition for treating cancer through nano emulsions. Next. Now we have total 30 forms available during the filing of application for a patent. So I am only quoting 4 important forms, that is form number 1, form number 2, form number 3, form number 5, and 18. So out of these different forms, form 2 is very important as it is considered as the heart of the patent. So it consists of a detailed description. Next. So this form 2 consists of detailing of the invention, field of invention, background of invention, objects of the invention, summary of the invention, detailed description, examples, claims, figures and drawings, and abstracts. So, for example, my field of invention was pharmaceutical sciences, and the composition which have been formulated non-emulsion was drug is rosuvastatin and ketorolac. So these are the two drugs I have taken. One is a lipid lowering agent and second is NSAID. So apart from lipid lowering agent activity and NSAID activity, I have found that these two drugs have potential cancer anti-cancer activity. So have formulated because of poor bioavailability of rosuvastatin. I have opted nano-emulsion formulation. So I have chosen two surfactants and formulated a nano-emulsion. And drug estimation was done by using HPLC, gradient HPLC. So where I have found that drug release studies were done and pharmacokinetic studies also be carried out. And cancer activity we have done in vitro cell lines. We have conducted our anti-cancer activity of these two drugs as a formulation, and we have sent the formulation to Mumbai, ACTRAC Mumbai, where they have performed on breast cancer cell lines, and we have found that when we compare the images after we have received, where there was a decrease in number of cells after treating with this nano-emulsion was very high. So we have concluded that these two drugs have active anti-cancer activity. So immediately we have filed a patent, and we have gone through all the steps of the patent, and we have received a grant recently. And after filing the patent only, we have gone for publication, and we have got 2 publications in peer-reviewed journals with impact 2 and 2.5. So while describing our innovation, we have followed all these steps, and whenever we are going to write a claims, being a researcher, we may miss some points. So we have hired a patent attorney who have helped in designing the entire research. So which has helped us in writing the claims where we can avoid the infringement. So it is a legal document. So the intervention of attorney is very, very important. Next slide. So we have approached whenever we have filed a patent, as you heard that I have filed more than 6 patents. Our database is being searched by number of industries and research institutes. So we have received a mail from Kalam Institute of Health Technology, which is supported by Department of Biotechnology, Government of India. So those people have approached us for commercializing our invention. I'm not talking about the invention which is nano-emulsion. I'm talking about hydrogels. So we have formulated some hydrogels in our laboratory. So these laboratory we have, which are in hearing stage now, and these formulations were been attracted by this institute. So they have come forward and they have given an offer for technology transfer. So we have a MOU with them, and we have signed it, and it's in the process of e-auction. So where we are going to quote our price for this technology transfer of our hydrogels. Mainly we have used 2 antibiotics, ciprofloxacin and meloxicam. So these are the 2 drugs which are having active anti-cancer activity, which is also proved by ACTRAC Mumbai. So why I'm discussing this topic is because technology transfer and capture of technology are very, very important even when you file a patent. So if you are filing a patent and leaving it as it is a mere waste of your time and money. So whenever you are going to convert your patent into a commercially viable, which can be serving the society. So I want to discuss few points regarding this transfer of technology and capture of technology. And coming to transfer of technology, sum total of all efforts which results in utilization of research for commercial production of goods, improvement of existing processes, development of new technologies, etc., all of which ultimately contribute to the progress and growth of society. So capture of technology, it is the process by which an industry is able to get hold or capture a technology from an external source, which may be a public funded research institute, which is situated within the country. Next. So steps involved in transfer of technology. So there should be a proper research, because once you start your work in your research, try, as I said, we need to have a thorough patent database search. Once you find that this method is going to hit the market with a good patent availability, and it should have a reproducible. Whatever the results you are generating in your laboratory should reproducible. When you approach industry, or whether it is small scale or large scale industry, whenever you're presenting your research to them, if they work on that, it should be reproducible. So there should be a proper research and proper work. Proper work, paperwork includes whenever you're filing, when you're about to publish your article, how you're going to write introduction, materials or methods in detailedly. In the same way, we need to have a thorough knowledge on various documents related to patent. So there should be a proper paperwork. And once you are done with these two steps, this is pricing. The pricing part is very, very important. Whenever your patent is being approached through a database by various industries, then the question comes the pricing of your work. So the pricing should not be too high, or it should not be too low. If it is too high, you may not get a good uh, industry to take over your work. If it is too low, you may get ended up with the loss on your work. So it should be a negotiable between the investor and the patent holder. Publicity, and as Vijay Kumar sir and Ambika Banerjee has said, that publicity is very important. Nobody is going to look after you. You are sitting in a laboratory and doing the research. There should be some person to know your research. So there should be a publicity. The publicity can be done by good networking. Try to present your work in various conferences. Try to discuss with the industry people. Try to mail them, and the mailing should be specific. Suppose you have eye drops formulation, you're contacting a cardiovascular drug manufacturer, that won't be viable. So we need to have a publicity to be done to the right person at the right time. And partnerships. So when you partnership should be, that is how we are going to sign a memorandum of understanding between the industry. So whether you are going to have a exclusive rights or non-exclusive rights. For example, in the COVID time, we have seen the vaccines are being manufactured by multiple industries, so it is non-exclusive. So depending upon your work, you need to decide whether you want to give a non-exclusive or exclusive rights of your work. And the last is very important, people's acceptance. So people's acceptance is very, very important. Suppose the work which is been not been accepted by the public, whom you are targeting, the society, is merely waste. For example, if you are producing a plant variety which is genetically modified, that may harm the society. So people's acceptance is very, very important. Whatever the formulation, whether irrespective of it is pharmacy or any plant variety, that should be publicly accepted. So these are the steps involved in transfer of technology. Next. COT, that is capture of technology process. So capture of technology is very much close to TOT, but here we have been having two major players here: knowledge creators and knowledge users. Institutes, public funded research organizations, colleges are knowledge creators, and knowledge users are the people who are seeking the knowledge, especially the industry people who are running the organization for the manufacturing of various products. So all the institutes should build a COT SL where it can coordinate, and where the industry persons will be coming to your laboratory. They may send the R&D department scientists to your institute and work together for a period of time by signing a MOU with the institute, where technology can be merely exchanged at the initial level, whereas transfer technology is an end level. After completion of your entire work, you're approaching a industry. That is a tedious process. In a capture of technology, if you're perfect about your work, when you're confident about your work, about your research, you can have initial process of this thing, and where the industry people can join hands with you at the initial stage, and where we can get results with 0% R&D investment for the end users, and they can pay huge royalty to the institute. This is regarding COT process and integration of intellectual property rights in research. So how to integrate this intellectual property, especially in terms of patents and research of any researcher who is pursuing masters or PhD in universities. He should have a regularity in searching the database. During the search of literature review, he should have a thorough knowledge on the type of work he's going to do for the research. So as we heard that these research database, especially if you take Indian patent, every Friday they are going to release the publication. So these journals are, you keep a day for searching of these publications every Friday, and then you need to start your work. Search. So searching of right uh, so most of the mistakes done by the researcher is they are going to search only the granted patents search. So they are ignoring which has been publicized. So there should be a parallel search of both journals which have been in publication as well as in the patents. So special precautions should be taken to the Indian journals. As I said, they are not going to be available on net. So they are always offline. We need to go to the site, then we need to find that. And getting full text, previously it was very difficult. Now we can go to the website, go for search of application. If you know the application number of the patent, just clicking on that, you can get detailed description of right from the stage of filing of a provisional, complete to the hearing process. Each and every document is available in the website, so we can have a complete description of work, including results, information and retrieval. So ensure that you maintain a file in which you regularly enter data on searches carried out, and with the help of keywords where you can easily retrieve the information what you have formulated. So it will be better if you use hard copies rather than soft copies. Patent filing. So once you are regularly monitoring patents, you at once come to know whether any invention in your work lab is patentable, or else if it will be a duplication of your work. So try to uh, clearly search uh, of your work and keep ready the templates. As I said, in the COT process, we need to keep ready all the different forms which are very keen in applying a patent. So templates should be very much ready. And knowledge. So search out of the potential buyers of your research from patent databases and actual interactions with the possible buyers. So we need to have a thorough knowledge of your research to whom you are going to target. And we have a detailed policies of rules and regulations of the IP, where we can have that these policies and rules can be easily dealt when you seek a advice from Attorney General. Okay, this hello, sir, is over, sir. Thank you, sir.
Thank you, sir. Now I would like to request respected Chairman, Dr. Prashanth Mandal, sir, to ask about any queries.
Thank you, Manisha, for your lecture regarding the patents and the process, how it was done, and in detail you have described. Uh, I would like to request any participants having any queries regarding this, they can ask.
I have a question, Dr. Manish.
Sir.
You told that the time from application file patent application to granting is one year, 12 months, correct?
From where, sir? From publication to?
application of the file, application
To
of the patent to granting of this time gap is 12 months. That's
not
what you
sir,
say.
it's not 12 months, sir. It is 3 to 4 years, because I'm saying about complete provisional specifications to complete specifications. It is 12 months.
And for this you are talking of conventional product formulations. Suppose it is a
No,
formulation area.
traditional. It's a traditional, sir. Indian patent. I'm talking about not PCT. It is only traditional, regular patents.
So suppose if we go for oral control release product in formulation, then what would be the timing?
So whatever the invention, sir, when you have a idea, initially if you not started your work, you are in the bench stop stage. You are not yet started your work. You better go for provisional patent. When you have a results and generated data with you, then you can go for complete specification. Then from
No,
that period,
okay, that is a different thing. I'm asking the time frame. I'm asking specifically the time frame from the application of the file, application of the patent to granting of the patent.
48 months, sir. It's 48 months, which it took to my patent. So for my patent, it took almost 48 months, right from
This is,
beginning of.
so this 48 months you are telling for conventional formulation as well as control release formulation, both. Because control release formulation has got a lot of work, a lot of information to be shared. So how
Sir,
it can be same?
what is second one? Can you repeat again the question? Which
My
patent, sir, you're
question is,
asking about?
my question is, what is the time gap or time requirement from filing a patent for
Okay.
oral control release product up to
Oral,
granting? If it is
oral,
granted.
what is it? Oral,
Oral control release product.
oral
CRP.
control release. Okay, is it a tablet formulation or what, sir? You're talking about? It's a
Tablet.
tablet,
Tablet.
oral. So for sustained release, you're talking about.
Oral control release. Yes. Oral control
Okay.
release.
So you
Product.
can take my example, sir. My formulation is also a sustained release. It's a nano emulsion. So it took 48 months. So there is
But
no
is it,
specification that oral formulation will be having less and traditional drugs will be having the same. So
and
the
suppose
same
if we go for long-acting injectable formulation, that is also a control release product. Long-acting. I'm giving an example. I'm giving an example. It is a
Okay.
suspension. It is a
Okay.
suspension of, say, for example, medroxyprogesterone acetate.
Some
Depo-provera
formulation.
type.
Okay.
So in that case, what will be the
So,
time?
so that I don't have any idea, sir, because
No,
regarding
what I want to know from you, there must be some guidelines for each and every activity to be furnished at the time of patent filing, and then they examine and review all the individual task analysis to reach the time gap. This is the normal way of working they follow.
sir,
My
one thing
question to you-
one thing I want to clear that whenever you are going for provisional or complete, there won't be anything to be stopped in between. It clearly published within 18 months, you are going to get your publication. So once work has been published, from that it takes 48 months because it has been thoroughly reviewed by the expert in the patent office. So whatever you are going to file, whether it is a sustained release or a nano emulsion or conventional dosage forms, any innovation, there is nothing to be stopped in between from date of filing to 18 months. So
No,
once it's been public domain, then actual oppositions or thorough examination starts.
but that there my question is that 48 months is necessary for a simple conventional formulation and a complicated oral control release formulation or oral control release injectable formulation. How it can be
So,
same?
so
Because
that all
activities.
depends. That all depends upon the opposition, sir. The whatever you are going to file, depending upon the oppositions, it will be that is the time period given for any opposition. The 48 months is a mandatory from the 18 months. So you are having 30 months in hand. 18 months is for getting publicized. From 18 to 30 months, it is given period for opposition. So that period is being for giving to the public domain to raise the questions on your work.
Anyway, my second question is that suppose if a person, if a pharmacist is also a lawyer, like our Dr.
Shivko, Vijay sir.
So in that case also, whether we should recruit or whether we should take help from some patent attorney and
Patent attorney is if you are well much versed in your claiming part, because claiming part, as I said, is very, very important work to be done in filing complete specifications. The claims decide whether to make the oppositions nullify. If you're not properly writing the claims, it gives a chance for to because whenever you are going to for a patent publication, it is a public domain. So somebody has seen your work, they can easily get the complete data. So if they found that there is some space to be added up, they can add and they go for a patent. For example, I have used co-surfactant in the nano emulsions. I have given the percentage from 5% to 95%. I never disclosed the actual percentage what I have used during the preparation of this nano emulsion. So I have started from 5% to 95%. So I given an entire range where nobody can come in between.
No, doctor, that is not only given in the prior art and claims. Whatever
Yes.
is being done or whatever is not being done, that is because of the fencing.
Yes.
Some gentleman was telling about fencing sometimes back. I think Dr. Banerjee. It is a
Yes.
fencing act. I'm not asking that. I'm asking that if a person, if a developer or inventor is having both technical scientific background as well
he
as,
can go, sir. He can go because he have a thorough knowledge. He can well write the claims.
so he does not require patent attorney separately.
No,
correct?
not enough required.
Thank you.
Not
That's
enough
what I'm asking.
Yes, sir. Sanjit, sir, anything? Any questions?
So any questions, participants? If you want to ask any question to Dr. Manish Kumar, please go ahead.
I think Dr. Manish Kumar has given a very in a simple way the different aspects of the patent. That's why there are less questions. He has clarified all the doubts during his lecture.
Sir, actual thing is that there was a repetition of the same thing over the day.
Yes.
So that's the reason I have been concentrating on the work what have been done, so which I got the grant.
Yeah,
So that area that was the area which I was more focusing. And the thing which I have been delving is that regarding technology transfer, why? Because I have been approached by a national institute that, as I said, KHT, Kalam Institute of Health Technology, which is being supported by DBT. So during there was an exchange of some documents between us. So that was in the process. We are in the process of e-auction now. We are about to bidding our price to them. But it was a different formulation. It is hydrogel formulation. I'm not talking about nano emulsion, which has been granted, because I have a series of patents we are about to grant now, which are in the hearing stage now.
Okay.
The advantage of India and US patent is that we can go for provisional, then we can go for complete. But other countries, they are completely asking complete data, which is almost equal to your complete specifications. So my advice is that whenever you have a generated in area, just go for a patent filing. After then, you can go for publication. That is merely a good idea.
Manish sir, I have one question. That I have seen that you have some other Australian and
yes. Australian, South
patent,
African.
And another one South African patent I have seen.
Yes.
So whether the patent filing process and everything is quite similar, or for them different way we have to represent or something?
Frankly speaking, the time taken by the so that, for example, you have taken Australian and South African patent. The time period is very much less. Because why? Because they have not asking you a provisional thing where we need to wait for 12 months. You need to start your filing part after complete work. So that's the advantage of where you can cut down the time.
Yes, sir. I think from the participants, they have not more any questions. So thank you, sir. Thank you for accepting the invitations, and I'm hand over the session to Dr. Sritama Sarkar, madam.
Yes, thank you, Dr. Manish Kumar, for such an informative talk. And I would like to thank Dr. Prashanjit Mondal also for chairing this session. And thanks to all the participants and dignitaries and faculties of both the Department of Pharmaceutical Technology and Department of Biotechnology, Brainware University. And also thanks to the students for making this session a success. I'm handing over this to Bromojit, sir.
Yes, ma'am. Thank you. Thank you, madam. So now it's time to conclude this session and start the culture program session. So before starting that, it will be an immense pleasure for me to give the vote of thanks on the behalf of the Pharmaceutical Technology and Biotechnology Department, Brainware University, to the speakers. So very good evening, our honorable chief guest, Dr. Shankar Gangopaধ্যায় sir, keynote speaker, Dr. Vandana Pattabal madam, respected speakers, Dr. Ambika Banerjee sir, Dr. Vijay Kumar Shipuje sir, Dr. S.K. Mitra sir, Dr. Manish Kumar Thimaraju sir, and I also want to give thanks to our respected chairpersons, moderators of the seminar, our cultural coordinators, graphics and designing team, and technical team for their immense support. It's a very pride moment for me that I got a chance to work in this special session. Again, I want to give thanks to our HOD sir, both of the departments, for conducting such informative seminar. It is such an honor for me to get the opportunity to thank you all the dignitaries. On the behalf of the Pharmaceutical Technology Department, Brainerd University, I extend a warm welcome to all the people present in this seminar. I would like to express my gratitude to all the delegates to the seminar for their presence and contribution to make this webinar a great success. I extend my gratitude to our honorable guests and honorable speakers to take out time from their busy schedule to grace the event. And we have already learned so many things and acquired a great knowledge from this webinar. Thank you for your inspiring and encouraging us with your words. And a special thanks to our respected HOD sir, Miss Piali Khamkat madam, Vivek Barik sir, and all of the staffs of the Pharmaceutical Technology Department for providing the immense support to make this webinar successful. Thank you everyone once again for making it a great success.
Thank you, Brahmajit. In fact, for conducting these sessions, morning to evening. And yes, now it is for a short while for concluding session and then this cultural program. Now, we don't want to extend much more, but I think in this session, we are very much happy that Dr. Mitra is there, Dr. Manish Kumar is there, and Dr. Samarjit sir is there. I think, is it Samarjit sir or Sitama madam? Is your head of the department is present?
Sir, Ayushman sir, our head of the department is in another meeting in the boardroom.
Yeah,
right now.
boardroom, yes, he
Yeah.
is there. Okay, okay, no problem. I think this is at the outset, I think our Dr. Ambika Banerjee also there. Is he there, I think? Anyhow, so at the outset, let me express my gratitude to everybody. And it was basically, we had this objective of this webinar is to discuss thoroughly about this IPR and industry institute collaborations. And all these aspects, we very much happy to have this very eminent and distinguished speakers from very morning itself. Professor Vandana Patravali, no doubt, his eminence in the subject and the field and her experience in this patent as well as these collaborations. She has shared these views also. And then this first scientific session by Dr. Ambika Banerjee, a long time work as a head of this R&D in the East India Pharmaceutical Limited. Then he has very exclusively elaborate. And then we have Dr. Shipuje. He also very thorough about this patent and particularly patenting from this institute and the industry. Later on, it was a very thought-provoking and brainstorming session by Dr. Mitra and Dr. Manish Kumar. So overall, this 4 scientific session and 1 keynote address, which I think fill up the gaps regarding the patent and this collaborations with the industry, the need of these collaborations, and particularly in respect of this the patent. So I hope this webinar, it makes remarkable image in the minds of these participants and students, staff, all who are present here. I think this record will be available, and this record will be sent to everybody can view also. Now, in this regard, I just take some view that how this session you feel about it. A few of the eminent persons who are present here. Beyond that, there are scientific sessions, obviously. Sir, from biotechnology department, sir, you can, Dr. Samarji said, or you can express how you feel overall this webinar, and then these speakers are there also.
So I think it is a very interesting and very informative seminar. So all of you are, we actually enjoyed this seminar, and hopefully, so we are also doing different types of research work. So in the future, we can also do patents to our product. So I think this way our department also benefited lots from this seminar. So I think so that's all from my side.
Yes, fine. Yes, Sitapa madam, do you feel that this seminar or this type of discussion should be arranged in future also for the benefit of the department?
Yes, sir, obviously, because I think today's topic from morning to evening, everyone has talked so much about patents and IPR. Those are not completely a pharmacology perspective, but also from biotechnology perspective,
Yes.
since we are also researchers, and we also will need these informations very much, and in future we can work hand in hand, and obviously all these informations will be very helpful to us.
Okay, thank you, madam. Dr. Mitra. Dr. Mitra, are you there? Dr. S.K. Mitra.
Yes.
Yeah, how you feel about this webinar overall?
I feel that this is a very virgin field in the field of pharmaceutical and biotechnology.
Yeah.
So for that, I believe some physical mode, if you can do this kind of one kind of workshop, and all research scientists and faculties who are doing research work in the field of pharmaceutical technology or biotechnology, and then I think it will be more valuable for them to make the program or research, write the research project, and asking the funding from the different funding agency. Because now lot of industry is there. I know some Hyderabad based and the Bangalore based industry is there in Pune based, that they are also very much eager to fund the institute if there is a suitable project for R&D. So you can make fast collaboration, so then it will be benefit for you that whenever you will obtain patent, that your patent will be bought by that company, and don't need to go search the customer where I will sell my technology. So that will help you for earning and to continue your research with the fund available from that particular commerce house, that means the industry also. So I am running one center for intellectual property right at Adamas University, and that center is not for Adamas only. That center is for all institutes, and the fund is coming from government. So for that, if you need any sort of help, then you can meet my center and I can advise you and what planning or roadmap you require to write a project and to ask the fund from the funding organization, not only the government fund. I'm not talking about government, the private fund, because government fund only will provide fund, but they will not purchase your patent. But industry fund will purchase your patent. What the IITs are doing. IIT, before starting any research project, through SRIC, Sponsored Research Industrial Consultancy Service, they are taking project from the private company like Tata, Birla, Reliance, and other companies. And after getting the solution, when they are giving the right to them, they are further funding to them for going further research or further improvement. This is an opportunity. So I believe this kind of roadmap you can prepare based on your creation and research, then your institute will get the benefit, and the person will get benefit, and the sustainable research will be possible.
Exactly, sir. What our university also wants like this, and we have a thorough discussion going on.
Okay.
University industry tie-up, linkage, projects, collaborations, and funding and all these things. So, in fact, your suggestions for this offline workshop or physical workshop where, yeah, we can finalize some projects also and some collaborations also. Yes, a good suggestion, I think. I think we'll see that in the future, if possible, we will do it. Right? Thank you, but you will be always with us to
No
guide
issue.
us.
When I have promised, so certainly I will be with you.
Yeah. Thank you. Although Dr. Manish sir, beside your this, I mean, scientific lectures, the overall view that we university we have started, of course, and you are also in the Telangana in the Educational Institute. How you feel about this webinar?
It was wonderful, sir. It was the way of the picking of the speakers is very good, because what are the I've seen the list of speakers, all are eminent. And one suggestion I can give, that being a university, you can approach Ministry of MSME for IP Facilitation Center. So they are going to give you 65 lakhs rupees for the fund, seed grant. So where we can install this IP Facilitation Center. So where it helps to, it functions as an incubation center for your research, because we have Department of Biotechnology and pharmaceutical technology. So huge research is going on, and you have a good number of PhDs. So this center will help you in generating more number of patents. Because being a university, it's mandatory for getting the NAC or NIRF ranking. So I have seen the competing of different universities in number of filing patents. LPU is filing more than 400 patents this year. So this decides the growth and fate of the institute in terms of ranking. So you have a huge opportunity being UGC recognized university. So you have all the facilities to apply for this MSME grant, sir. And at the same time, ACT is also giving Kapila, that is the initiative, where 80% of the publication charges are waived off. So where all the researchers can avail this opportunity, because going for a patent individually, it's a huge cost. So it ends up around 1 lakh when the person reaches from publication Part-2 grant. So that can be cut down when you start this incentive given by the government of India, that is Kapila initiative. So these are the things I want to suggestions from my side. And overall, the webinar is wonderful, sir. I'm very much privileged for being a part of this webinar. Thank you, sir.
Thank you, Dr. Manish Kumar. If you are coming to Calcutta sometimes, please let us know. You can have a visit to this our university and departments, right? We'll
Thank you, sir.
have some physical discussions. Now, anybody else from this audience? Where is our Mr. Our Prashanto Kumar Chakraborty? Sir is there? Mr.
I think he got disconnected, sir.
Disconnected.
Yes, sir.
Okay, anybody? Mr. Dr. Prasenjit Mandal, your overall view?
Sir, all the sessions are very much interactive, and specifically the faculty members, we came to know lots of things about that. Though I have filed few patents, but still after that, so many steps is there to go ahead. So from the Professor Mitra and Dipasi Banerjee sir, Vandana Patrole Madam sir, Dr. Manish sir, so all of them have given clear knowledge and give a correct path. So that was very much informative in all the sessions, and the way it was organized, that was also very nice. And overall, I was satisfied, and I hope in future I will communicate all the speakers personally to go ahead with my work. so that I can do something better in this sector. Thank you, sir.
Anybody, any staff member from pharmacy as well as from biotechnology? Anyone want to say something? Their opinion? Any comment on this webinar? From biotechnology, any faculty member or any staff members are there? Or from pharmacy? Okay. So you come to the end of this session.
Sir, before concluding, sir, I would request to my technical team to show the certificates of
Oh,
the
yeah,
Mitra
yeah,
sir
that
and
remain incomplete. Okay,
Manish
okay.
sir. Okay.
Please proceed.
So I would like to request our technical team to please show up the certificates of Dr. Mitra sir and Manish sir.
Thank you again. This certificate.
Thank you, sir.
Also.
I think all these certificates will be sent by mail, and I think all chairmen also of the sessions, they will receive their certificate also, as well as this the moderator and participants. I think they need that feedback forms to be filled. Is it
To get
so?
the certificates. Yes, sir.
Yeah.
Everyone is requested to fill up the feedback form to get the certificates.
Right. Is it feedback form is given in that
Yes, sir, I have given in the chat box.
chat box? Okay, please, everybody, all the students can fill up and you can get it. So finally, we come to this conclusion. I mean, this end of this the sessions, and at last, this again on behalf of this organizing committee as well as from the university and both departments, we express our sincere gratitude and thankfulness to our resource persons and the chairpersons as well as these moderators. They are in fact organized very nicely these sessions without any difficulty. We have smoothly conducted these sessions, and I think this session also create a lot of enthusiasm and lot of inspirations for participants, and if possible in future days we'll also do such type of event. So including this organizing committee and participants, I thank you all. So we come to end of these sessions. It will be followed by the cultural activities. Please wait for some time. Yes, Brahmajit or other sections. Yes. Sir.
Yes, sir. Please give us the permission to continue the
Just
cultural programs. So, cultural.
Thank you, sir. Now, so we are back to entertain you all. Now coming up with a recitation by Shayon Koel from B Farm second year.
কেউ কথা রাখেনি। ৩৩ বছর কাটলো, কেউ কথা রাখেনি। ছেলেবেলায় এক বষ্টুমি তার আগমনী গান হঠাৎ থামিয়ে বলেছিল, শুক্লা দ্বাদশীর দিন অন্তরাটুকু শুনিয়ে যাবে। তারপর কত চন্দ্রভূক অমাবস্যা চলে গেল, কিন্তু সেই বষ্টমী আর এলো না। 25 বছর প্রতীক্ষায় আছি। মামাবাড়ির মাঝি নাদের আলী বলেছিল, বড় হও দাদা ঠাকুর, তোমাকে আমি 3 প্রহরের বিল দেখাতে নিয়ে যাব। সেখানে পদ্ম ফুলের মাথায় সাপ আর ভ্রমর খেলা করে। নাদের আলী, আমি আর কত বড় হব? আমার মাথায় ঘরের ছাদ ফুঁড়ে স্পর্শ করলে তারপর তুমি আমায় 3 প্রহরের বিল দেখাবে? একটা রয়্যাল গুলি কিনতে পারিনি কখনো। লাঠি লজেন্স দেখিয়ে দেখিয়ে চুষেছে লস্কর বাড়ির ছেলেরা। ভিখারির মতন চৌধুরীদের গেটে দাঁড়িয়ে দেখেছি ভেতরের রাস উৎসব। অবিরল রঙের ধারার মধ্যে সুবর্ণ কঙ্কন পরা ফর্সা রমণীরা কত রকম আমোদে হেসেছে। আমার দিকে তারা ফিরেও চায়নি। বাবা আমার কাঁধ ছুঁয়ে বলেছিলেন, দেখিস একদিন আমরাও। বাবা এখন অন্ধ। আমাদের দেখা হয়নি কিছুই। সেই রয়্যাল গুলি, সেই লাঠি লজেন্স, সেই রাজ উৎসব আমায় কেউ ফিরিয়ে দেবে না। বুকের মধ্যে সুগন্ধি রুমাল রেখে বরুণা বলেছিল, যেদিন আমায় সত্যিকারের ভালোবাসবে সেদিন আমার বুকেও এইরকম আতরের গন্ধ হবে। ভালোবাসার জন্য আমি হাতের মুঠোয় প্রাণ নিয়েছি। দুরন্ত ষাঁড়ের চোখে বেঁধেছি লাল কাপড়। বিশ্ব সংসার তন্ন তন্ন করে খুঁজে এনেছি 108টা নীল পদ্ম। তবু কথা রাখেনি বরুণা। এখন তার বুকে শুধুই মাংসের গন্ধ। এখন সে যে কোনো নারী। কেউ কথা রাখেনি। 33 বছর কাটলো, কেউ কথা রাখে না।
Thank you, Shayan, for your recitation. That was quite touching. Now let's cheer up with a dance performance by Joya Ghosh from 3rd year.
बावरा मन देखने चला एक सपना, बावरा मन देखने चला एक सपना। बावरी सी मन की देखो बावरी है बातें, बावरी सी धड़कने हैं, बावरी है बावरी सी करवटों से निंदिया दूर भागे, बावरे से नैन चाहे बावरे झरोकों से, बावरे नजारों को तकना। बावरा मन देखने चला एक सपना, बावरा मन देखने चला एक सपना। बावरे से इस जहां में बावरा एक साथ हो, इस सयानी भीड़ में बस हाथों में तेरा हाथ हो। बावरी सी धुन हो कोई, बावरा एक राग हो, बावरी सी धुन हो कोई, बावरा एक राग हो।
I hope everyone enjoyed the performance. Now bringing up a song by Lisa Vishwas from BPharm second year.
নমস্কার। আমার হিয়ার মাঝে লুকিয়েছিলে, দেখতে আমি পাইনি, তোমায় দেখতে আমি পাইনি। আমার হিয়ার মাঝে লুকিয়েছিলে, দেখতে আমি পাইনি, তোমায় দেখতে আমি পাইনি। বাহির পানে বাহির পানে চোখ মেলেছি, বাহির পানে আমার হৃদয় পানে চাইনি, আমার হিয়ার মাঝে লুকিয়েছিলে, দেখতে আমি পাইনি, তোমায় দেখতে আমি পাইনি। আমার হিয়ার মাঝে লুকিয়েছিলে। আমার সকল ভালোবাসায়, সকল আঘাত, সকল আশায়, আমার সকল ভালোবাসায়, সকল আঘাত, সকল আশায়, তুমি ছিলে আমার কাছে, তুমি ছিলে। আমি তোমার কাছে যাইনি, আমার হিয়ার মাঝে লুকিয়েছিলে, দেখতে আমি পাইনি, তোমায় দেখতে আমি পাইনি। আমার হিয়ার মাঝে লুকিয়েছিলে। ধন্যবাদ।
Thank you, Lisa, for your song. It was simply wonderful. Here's one more recitation by Shubhan Mishra from BPharm second year.
প্রেম, কবি শুভ দাশগুপ্ত। 4 অক্টোবর তাদের দুজনের প্রথম দেখা হলো। তখন বিকেল ঘনিয়ে আসছে, বাতাসে শীতের আমেজ। 10 অক্টোবর তাদের দীর্ঘক্ষণ কথা হলো টেলিফোনে। সেদিন ছেলেটি নতুন কেনা টবে গোলাপের চারা লাগালো। 30 অক্টোবর রেস্টুরেন্টের নিরালা কেবিনে ছেলেটি বলল, তোমাকে আমি ভালোবাসি। মেয়েটি লজ্জায় মাথা নিচু করে টেবিলে আঁকিবুকি কাটলো। 12 ডিসেম্বর গোলাপ গাছে কুঁড়ি ধরলো। মেয়েটি রেস্টুরেন্টে ছেলেটিকে জিজ্ঞেস করলো, কেন ভালোবাসো আমায়? আমি সুন্দরী তাই? তোমার চেয়েও সুন্দরী আছে কত? আমার বাবার প্রচুর অর্থ তাই? তোমার বাবার চেয়ে বড় লোক এখানে কম আছে? তাহলে ভালোবাসি ভালোবাসি, তার আবার কারণ হয় নাকি? মেয়েটি বাড়ি ফিরে বন্ধুদের টেলিফোনে অনেক আলোচনা করলো। সবাই এক বাক্যে বুঝিয়ে দিল, ভালো যখন বাসে তখন একটা কিছু তো কারণ আছে বটেই, সেটা না বুঝে বেশি এগোস না। 3 জানুয়ারি মেয়েটি বলল, আমার কাছে কি চাও? কই, চাইনি তো কিছু। ভালোবাসো অথচ চাও না? তাহলে না চাহিলে যারে পাওয়া যায়, দেওয়া গিলে আসে হাতে। এত গান, শুধুই গান, তাছাড়া কি? কিছুই যদি না চাও তবে ভালোবাসো কেন? ভালোবাসি তাই ভালোবাসা দিতে চাই, চাইবো কেন? তুমি সত্যিই অদ্ভুত। 10ই ফেব্রুয়ারি দুজনের দেখা হলো মেট্রো স্টেশনের পাতালে। ছেলেটি বলল, আমি কাল সারা রাত বাঁশি বাজিয়েছি। সারা রাত সেই সুরের মায়াবী আলোয় তুমি নাচছিলে, অসামান্য অনন্য সে নাচ। ধ্যাৎ, কাল সারা রাত আমি ঘুমিয়েছি। আমি কিন্তু তোমার নাচই দেখে গেছি সারা রাত। তোমার বাঁশি একদিন শুনতে হবে। 12ই মার্চ ছেলেটি বাঁশি বাজালো, মেয়েটি শুনল। সময় থমকে রইল অনেকক্ষণ। বাঁশি যখন থামলো, মেয়েটির দু চোখ ভরা জল। বলল, বাঁশি শুনতে শুনতে আমার ঘুম এলো আবেশে। আমি দেখলাম আমি নাচছি, মেঘের মাঝখানে তারাদের পাশে আমি নাচছি, আকাশে ফুলের গন্ধ। ডাক্তার আমায় বাঁশি বাজাতে নিষেধ করেছেন। সে কি, কেন? বাঁশি আমায় টেনে নিয়ে যায় স্বপ্নের মধ্যে। ডাক্তার বলেছে, স্বপ্ন দেখে আমার মস্তিষ্কের শিরা উপশিরায় জট পাকিয়ে যাচ্ছে। তাহলে ভাবছি। 16ই এপ্রিল মেয়েটি বলল, আমার বন্ধুরা বলেছে তুমি খুব ভালো, অসাধারণ, কিন্তু তুমি সৃষ্টি ছাড়া। তোমার স্বপ্ন সব অর্থহীন। আমি জানি। স্বপ্ন টপ্ন ছেড়ে দিতে পারো না তুমি? না। তাহলে তুমি এত আমাকে হারাবে? তোমায় পাইনি তো কখনো। 5ই মে ছেলেটির মস্তিষ্কে অপারেশন হলো। একটু সুস্থ হতে মেয়েটি এসে বলল, ভালো আছো তো? এখন আর স্বপ্ন দেখছো না তো? দেখছি আরো সুন্দর সব স্বপ্ন। তাহলে তো দেখছি অপারেশনটা আদৌ সফল হয়নি। বাড়ি ফিরে বন্ধুদের ফোন করলো মেয়েটি। বন্ধুরা এক বাক্যে বলল, বাঁশি বাজানো, স্বপ্ন দেখা সবই ব্যাকডেটেড, সৃষ্টি ছাড়া। তুই আর লোক পেলি না? তুই এত রূপসী, তোর এত উজ্জ্বল প্রসপেক্ট। ভালো যদি চাস তাহলে শিগগির বিয়ে করে ফেল তোর দাদার সেই বন্ধুকে। উনি তো শুনলাম কানাডাতেই সেটেল করবেন। 7ই জুলাই মেয়েটি আবার জিজ্ঞেস করলো, তুমি সত্যি কি চাও বলো তো? তুমি আরো সার্থক, আরো সুন্দর হয়ে ওঠো, ব্যাস, আর কিচ্ছু না। আর চাই স্বপ্ন দেখতে। ও, স্বপ্ন তাহলে তুমি ছাড়তে পারবে না? না, তাহলে থাকো তুমি স্বপ্ন নিয়ে। 12ই আগস্ট গোলাপ গাছে ফুল ফুটলো অনেক। সেদিন দুপুরে ছেলেটির মস্তিষ্কে আবার অপারেশন হলো। 13ই সেপ্টেম্বর ছেলেটি মারা গেল। 14ই সেপ্টেম্বর মেয়েটির শুভ বিবাহ সুসম্পন্ন হলো কানাডাগামী সেই পাত্রের সঙ্গে। 20শে সেপ্টেম্বর গোলাপ গাছটি হঠাৎ ঝড়ে উপড়ে গেল। সেদিন সন্ধ্যার বিমানে মেয়েটি হানিমুনে গেল। যাওয়ার আগে বন্ধুদের বলে গেল, স্বপ্নের চেয়ে বাস্তব অনেক ভালো, অনেক মধুর। স্বপ্ন দেখে কেবল বোকারা। 4 অক্টোবর ছেলেটির মা ঝরে পড়া গোলাপ গাছটিকে সযত্নে তুলে ফেলে দিলেন। শূন্য তবে তখন কয়েকটা পোকা, কয়েকটা মাছি। আমরা কেউ জানি না ওগুলো পোকা মাছি নাকি ছেলেটির স্বপ্ন। আমরা ঠিক জানি না, আমরা কেউই জানি না।
Thank you, Shubhayan, for enriching us with such brilliant recitation. Now, a few more performances are left. Let us welcome Moutrisha Dash from DPharm first year with her dance.
उसके जैसी न कोई नाज़नीं, शाही जोड़ा पहन के आई जो बंधन के, वही तो मेरी स्वीट हार्ट है। शर्माए से बगल में जो बैठी है दुल्हन के, वही तो मेरी स्वीट हार्ट है। शाही जोड़ा पहन के आई जो बंधन के, वही तो मेरी स्वीट हार्ट है। शर्माए से बगल में जो बैठी है दुल्हन के, वही तो मेरी स्वीट हार्ट है।
That was a stunning performance. I guess yes, everyone present here will agree with that.
Now, coming up with Bitan Kundu from BFAM third year for a concluding song.
তারে ধরি ধরি মনে করি, ধরতে গেলে আর পেলেম না, ধরি ধরি মনে করি, ধরতে গেলে আর পেলেম না। দেখেছি রূপসাগরের মনের মানুষ কাঁচা সোনা, দেখেছি রূপসাগরের মনের মানুষ কাঁচা সোনা। বহুদিন ভাব তরঙ্গে ভেসেছি কতই রঙ্গে, বহুদিন ভাব তরঙ্গে ভেসেছি কতই রঙ্গে, সুজনের সঙ্গে হবে দেখা শোনা। তারে আমার আমার মনে করি, আমার হয়ে আর হইল না, আমার আমার মনে করি, আমার হয়ে আর হইল না। দেখেছি ভেঙে মোর ঘরের চাবি, নিয়ে যাবি কে আমারে। ও বন্ধু আমার, ভেঙে মোর ঘরের চাবি, নিয়ে যাবি কে আমারে। আকাশের যত তারা চেয়ে রয় নিমেষারা, আকাশের যত তারা চেয়ে রয় নিমেষারা, বসে রয় রাত প্রভাতের পথের ধারে। তোমারই দেখা পেলে সকল ফেলে ডুববে আলোক পারাবারে। ভেঙে মোর ঘরের চাবি, নিয়ে যাবি কে আমারে। ও বন্ধু আমার, ভেঙে মোর ঘরের চাবি, নিয়ে যাবি কে আমারে। ও বন্ধু আমার, না পেয়ে তোমার দেখা, একা একা দিন যে আমার কাটে না রে। দেখেছি রূপসাগরের মনের মানুষ কাঁচা সোনা, দেখেছি রূপসাগরের মনের মানুষ কাঁচা সোনা।
That left us speechless. Such an hypnotic voice.
That's a wrap up to our cultural events. Feel free to share your feedback. The link is provided in the chat box. Before ending, we would like to thank everyone who has been part of this cultural event.
We are grateful to our technical team, Biraj Patro and Rajat Ghosh, and special thanks to Shunchita ma'am, Shumasri ma'am, Ria ma'am, and Saurabh Koviraj da for guiding us thoroughly. Now we hand over to our Brahmajit sir to say a few words. Over to you, sir.
So it was such an informative session. We have already attended and we have learned so many new things about this seminar. So it's the time to conclude this seminar. So as they have told, the feedback link is provided in the chat box and other platforms like Telegram and Facebook, Telegram and that WhatsApp groups. So you can fill up the feedback form and get the certificates. Okay. So good night to everyone. Hope for the best. If any further seminar or webinar is organizing by the Brainerd University. Keep in touch with our WhatsApp and Telegram group to get the updates. Okay. Okay. Thank you, everyone.